Burlington School Committee versus Massachusetts Department of Education, 1985. While in the first grade, Michael Bacchino was found to be handicapped. After 2 years in school, it became clear that the school he was attending was not equipped to handle his needs, and a new IP was created, which involved his moving to another school for the 1979-80s academic year. His parents, however, did not agree with the proposed IEP and requested a review. In the meantime, Nico's parents, at their own expense, enrolled him into a private special education school that was state approved. The Bureau of Special Education Appeals, BSEA, part of Massachusetts Department of Education, in 1980 decided that the private school was the most appropriate placement for the child. They directed officials in Burlington to pay the child's schooling and to reimburse his parents for the expenses that they had already spent. The town officials agreed to pay. However, they refused to reimburse for the 1979-80 school year because the revised IEP was still being assessed at that time. On March 26, 1985, the case was argued before the USA Supreme Court. The court recognized that the changes of placement if officials in a state or local educational agencies agreed with such modifications to be agreement with regard to the child's placement. The court concluded that the parents should be reimbursed because the private school was the child's appropriate placement. The decision of the First Circuit was affirmed. Alberti versus Clementon, 1993. Raphael Alberti has Down syndrome. When he was in kindergarten, he had some behavior problems at his local elementary school in the Burgerlementine in Philadelphia. He experienced potty training accidents, hid from his teacher, spit on other students, and hit the teacher's aide. At the end of the school year, administrators decided to transfer Raphael to a special education class. The class was in a different school district since no such class was available in Raphael's local school district. Raphael's parents objected. After much failed negotiation, they initiated a lawsuit. They felt that the Burger of Clementon School District violated the requirements of the IDA. The IDA is a federal law that requires schools to educate disabled children in the least restrictive environment. The Alberti versus Burger of Clementon School District case eventually reached the Federal Third Circuit Court of Appeals. The school district argued that Raphael was not prepared for mainstreaming, while the Alberti family presented experts who testified that Raphael could be mainstreamed with supplemental aids and services. The family argued that the district had not attempted to mainstream Raphael to the maximum extent appropriate. The court sided with the Alberti family. They developed an important two-part test to determine whether or not the school district met the least restrictive environment requirements of the IDA. Finally, in affirming the district's court's order, the school district developed a more inclusive program for Raphael in compliance with the IDA for the upcoming school year. Deal versus Hamilton County Board of Education, 2004. This case was initial in 1999 and reached the USA Court of Appeals for the Sixth Circuit in 2004. Zachariah Deal was autistic. When Zachariah turned 3, a Tennessee County Board of Education developed an IEP for Zachariah. During that year, Zachariah attended a preschool developmental class according to his IEP. However, his parents supplemented Zachariah's education at home with an ABA program using structured teaching, comprehensive data and collection and analysis. The Deals requested that the board funded the ABA program as part of Zachariah's end of school year services. The board refused to fund the program, but the Deals continued to use it with Zachariah. The following year, the Deals continued to meet with the board regarding Zachariah's accommodations and again requested and were denied for the funding of the ABA program. For the 1999-2000 school year, the board proposed that Zachariah attended a kindergarten developmental class. The Deals rejected the IEP because they still wanted the board to provide the ABA program. They also wanted Zachariah to spend more time in a regular class. The Deals requested a hearing before an administrative law judge in accordance with the Individuals with Disabilities Education Act, alleging that the board failed to provide Zachariah with the free appropriate public education FAPE and requesting reimbursement for the private education. The LAJ found that the board's predetermination of Zachariah's educational program and its failure to include Irregular teacher and IEP meetings amounted to procedure violations. Individually, which denied Zachariah FAPE. The board was ordered to reimburse the deals for the ABA program. In this case, there were no winners or losers. There were two individual units that learned from this case the need for clear interpretation of a law.